Hello and welcome to day 2 of the Will Writing Challenge. Yesterday we went through appreciating the value of a will, identifying the key players in the will, and setting out your wishes. Well, not quite. We'll be there today. Giving validity to your will and also making provision for your pets are some of the things we will be looking at today. I hope you got on well with trying to write your will yesterday, looking at your assets, your liabilities, deciding how you're going to choose your executors and trustees. Before we begin, let me introduce myself again. I am Deborah Bowers. I'm a STEP certified advanced will writer, a solicitor of England and Wales. I practice GDPR, which is data protection, having qualified on the CIPPE and the CIPM. I'm also the author of the lovely book, How to Write a Tax Efficient Will, which is available on Amazon. In its first edition, it was a #1 bestseller. And this book looks into not only will writing, but it opens your eyes to your exemptions. And it also looks into lasting powers of attorney. Before we begin, I need to give you a disclaimer. I will not be your solicitor as I'm speaking or advising or discussing these matters with you. This is not financial advice. It is not legal advice. It is not investment advice. It is not tax advice. This is an open discussion about will writing, and this is not a regulated activity by the Law Society. So you will not be able to say, oh, I was your lawyer when I wrote this will. We're simply having a discussion. This is for information purposes only. You trust, but you verify. The objectives, as we set out previously on day 1, is to understand how to prepare to write your will, roles and responsibilities of executors, trustees, and beneficiaries, how to distribute your estate, the residue, and attestation or execution of your will. Today we shall look at distribution of your estate. What would you like to achieve? That is really the question when you think of how am I going to distribute my estate? What are you trying to achieve? Who would you like to give it to? How would you like them to deal with it? And it means you're passing over your assets from you being in control to someone else when you are no longer here. Would you like to give all your assets to one person? Some people do that. They would like to give just everything they have to one person. Some people would like to divide it up and give it to different people, or would like one person to enjoy it for a period and then another set of people to have it. So that's why I asked the question, what are you trying to achieve? If you simply want to give all your assets to one person, you could write, I give, devise, and bequeath all of my estate to. You give the name of the person, you give their address and their relationship to you. That's if you just want to give your assets to one person. You can also give a percentage of your assets away. And that usually happens when you're considering giving something to a charity. So you can give a percentage of your estate to a charity by naming the charity, giving the charity number and or its address. So you might want to help the dog's home or the dog's trust. You give the name of the charity, you give the charity number, and you give the address of that charity. And so I give 10% of my estate to the charity, the Dog's Trust. The good thing with giving property to charity is that if, for example, your estate is above the threshold, if you have given 10% of your estate to a charity and you would have paid tax, that gesture reduces the amount of tax you pay. It doesn't take it away, but it diminishes it. Other things that people would like to do when they're distributing their estates, they might like to create a life interest. For example, we have the situation where You have a husband and wife, they got married late, they had children already, both sides had children. The woman moves into the man's house with her children and they live together. The man passes away. He doesn't want his wife to end up without a home when he's not here. He's loved her, they've loved each other, but the home does not really belong to the children that were brought in. It belongs to the children who were the children of the man. And he would like for the home at the end, when he's not there, after his wife passes, to go to the children from that relationship, because he acquired that home with that partner. The home is now his. Another partner came in. He doesn't want to leave her destitute. He wants to be sure she's taken care of. But when she passes, the home goes to his side of the family, not to her children. So if you are in a situation like that, you can put a clause in place, say, my trustees shall hold a residue of my estate, basically all of your estate, on trust to pay the income from my residuary estate to my wife or husband or civil partner during his or her lifetime, with power to pay or apply the whole or part of the capital of my residuary estate to the benefit of my wife or husband or civil partner. Now, I want to break this down a little. If you have already given gifts to other people at the top, whatever is left is called a residue. Excuse me. And the residue is whatever is left. So you give that to your partner, your wife or your husband or your civil partner. But in this clause, what you're also doing, you're also allowing that partner something else. You're allowing them a clause, which I'm going to show you next. So you allow them the capital, the home, but you also allow them the income. And subject to that, you allow them income so that they can repair the home, they can stay in the home, they can apply the income for their benefit. And you say, once they've done that for their lifetime, you then pass the property over, and subject to any exercise of that power after his or her death, to hold both the capital and the income of your estate, either in equal shares for those of your children by your wife or husband who survive you in equal shares. And also you're saying, if any child should die, if any of the children dies and they have a child, you want the part that they would have inherited to pass to their child. So we put that in a will by referring to a clause called pars turpis. It's the language of will writing. But this clause represents that. So the first thing which you have done, you've given the income, the capital and the income for the benefit of your partner during their lifetime. And subject to that, once their lifetime is ended, the capital and the income should be held by your trustees for the benefit of the children of the relationship that you want the property to pass to. And if any of those children have a child, and that child, well, the children that you have, your grandchild, their mother has passed or their father has passed, you still want them to inherit the property, you want the grandchild to inherit. So that's very important, because you're saying, okay, if one isn't there, the other one who is in their place should take in the same or equal, in the same manner. Some of us love our pets, and I've always found this so intriguing and wonderful when I write wills, because people really want to make provisions for their pets. And sometimes you hear people, they've left $1 million, 2 million, 10 million for the dog, their cat, because really and truly they had no one in their lives, and it was the dog or the cat that really was their close ally, their close friend, the person who provided them with love throughout their last few years. And so they've left these monies for their pets. So it's important, very important to some of us, to make provision for the pets that we leave behind. And a clause which you can put in your will is, in the event that I should predecease my dog or my cat. Then you name the pet. The pet might have its own name, destiny. I give, devise, and bequeath to, yes, the person, the person that you would like to give the property, the pet to. I see that I've got some errors in the event that, yes. So that's wrong here, and that's I was thinking in doubles at the time. But in the event that I should predecease my dog or my cat, I give, devise, and bequeath the name of the pet to whoever it is that you want to give it to, their name, their address, and their relationship to you. You can also indicate in your will how you wish to be disposed of, your body to be disposed of, either buried or cremated. Oh, sorry, I beg your pardon. I've got a bit of a cough here. You can indicate that you wish to be buried or cremated. And it's good to really tell people about that beforehand, because your will might not be dealt with much later. So you can speak to those that you believe that might be around after you're gone, and let them know your preferences. You can also put that information in a letter of wishes. Now, organ donation is something that has become very topical, because the law changed recently, and the law allows you to be automatically in agreement to donation of your organs. And if you do not wish to donate your organs, it is up to you to opt out. So if you wish to keep your organs, you need to go whilst you are alive to join and register a decision not to donate. So that information can be found on the NHS website. It's called www.organdonation.nhs.uk. Register your decision, do not donate. If you do not register, it is assumed that you intend or you would like to donate your organs. Of course, you can find out more about everything I have discussed here. You can find out more and gain access to my lifetime course. You have lifetime access to the course. You can help yourself, you can help others. It's reasonable to go through it. Plus, you have lots of templates along the way to assist you. And those templates and the course is found on my mastermind program. It's bowersdeborah.mastermind.com/masterminds 36966. So please get on to the mastermind program. Lifetime access. You have nothing to lose. You can help yourself, help others, and also save big. Now we're going to deal with ending off the will and making it a legal document. And these words that I have included here will assist you with that. As witness, my hand this day, date, and month. You put the year. Then you leave the space there for your signature. And you have to put this clause in so that the witnesses are saying and attesting that it has been signed by the testator in our presence and attested by us in the presence of the testator and of each other. And what this means is, you as the person who wrote the will is called a testator. You've got your witnesses. They're saying, we have seen this testator, this person signed the will, and we have witnessed it. That was all done in our presence. So we can say that it was done correctly. And of course, I have included these boxes here to show where these witnesses must put their name, their occupation, their address, and signature. And that would make your will a valid will. If you have any questions, I'm happy to answer them, or we can move on. So a will, some people sometimes ask me is, can you sign if you are disabled? It's best to have people who can see and who can read to witness your will, because you are attesting to something. So it's best to avoid confusion at all cost. If you have people who have all the senses, it's best. They can read, they can write, they can see. Okay, so let's move on to the next. Here is the book once again. It's How to Write a Tax Efficient Will by me, Deborah Bowers. It's available on amazon.co.uk. Please feel free to get your copy. It's $14.99, or you can do the course. Alternatively, if you would like, you could always subscribe and like my YouTube channel. There's a lot of free information there. You can go through the videos. Don't forget to like and subscribe. It does help the channel, and I appreciate it. If you wish to contact me, you can contact me via my website. It's Deborah Bowers Will Writing. Just type that into Google, you'll find me. Contact me via my YouTube channel at Deborah Bowers, or email deborahbowerswillwriting@gmail.com. You can also secure your course at bowersdeborah.mastermind.com/masterminds36966. Or you can call me, pick up the phone, call me 07950108796. I do hope that you have enjoyed the second day of the Will Writing Challenge and that you will be able to write your own wills. If you need any assistance, I'm here to help. I do home visits. I also do wills remotely. I write wills remotely once I can verify who you are. And I am more than happy to assist you in any way I can. Thank you for joining me, and I look forward to hearing from you that you have been able to write your own will. Congratulations, and thank you for joining me on the 2-day Will Writing Challenge.